Thank you very much, Alexander. Thank you for being enough patient to be here and remain in this last, or almost the last part of our conference. The goal of my paper, which is available, was to give a kind of overview on the 19-year-long history of national councils, legally entrenched and legally recognized national councils in Serbia, a kind of NTA, which have very specific circumstances in regard of their birth, circumstances how they were birthed. And we have a very dynamic process in changing the legislative framework around these NTI. So in this period, we have substantial amendments to the laws which regulated NTR. And there was a very important role in this process of the Constitutional Court of Serbia. I'm judge of the Constitutional Court of Serbia, but I'm not in that capacity here. I'm here as a researcher, and I was not a member of the Constitutional Court when this crucial decision, a benchmark decision, were made by the Constitutional Court of Serbia. So we have no time to elaborate all those data that I present in my work because 19 years, a lot of things happened. I will just pick up some of the issues which might be interesting around National Minority Council and this relationship between the legislator and the Constitutional Court, and to provide some actual unresolved issues and some conclusions in the end. So let's begin with kind of introduction. I am not able to move. Yes, it's first the birth and evolution of national minority councils in Serbia. Serbia is independent state from 2006. Before that, it was part of a various federations, or a common state with other South Slav nations in Yugoslavia. And the birth of national minority councils is in period in which it was a federal republic of Yugoslavia at that time. I just mentioned it for those who are not so familiar with these dates of the dismemberment of the Yugoslav federations. Serbia is even without Kosovo. The status of Kosovo is disputed. Serbian official point is that it is part of Serbia, but half of the world thinks differently. So these statistical data are without Kosovo. And even without Kosovo, Serbia is a multi-ethnic state. Around 15% of the population belongs to national minorities. These are the most numerous national minorities, the Hungarians, the Bosniaks, and the Roma. But we have also several minorities beyond 50,000 members. The birth of the national councils had a period in which national councils were illegal. So we have a period in which mainly the Hungarian political parties not only advocated various types of autonomy, including non-territorial autonomy, but they also established some provisional bodies, extra legem. So it was not within the legal structure of the state, it was a kind of political acting. But the moment when it was legalized was the year 2002, when the federal Yugoslav law on the protection of national minorities were enacted in federal parliament. So it is the starting point for us in this moment. And I would like only to tell two sentences on which were those moments, factors, which created this situation that the federal parliament enacted this federal law on the protection of national minorities, including the legal basis for the establishment of national minority councils. I determined three such factors, but none of these factors was the pressure of the international community. So no one really pressed Yugoslavia, Serbia, and Montenegro to accept a law which will include non-territorial autonomy and national minority councils from outside. It was a Hungarian political concept. So the Hungarian political parties push forward to implement into the law these articles about national minority councils, because all of them had a program which included non-territorial autonomy as well. So their concept was the basis, and because they were part of the post-Milosevic government, so they were in position to push forward this idea. So it was a Hungarian strong claim, but it's not enough to happen. What was another factor? That Yugoslavia, after the Milosevic period, tried to show a good human rights record, to show that it is ready to accept the highest standards in human rights, particularly in minority rights, because the war in post-Yugoslav, Yugoslav area was very much ethnic war. So in respect of minority protection, it was very important guest to show that we will have this kind of law. And also the international community very much welcomed this effort of Serbia. Not to have minority councils, but to have positive developments in human rights. The government accepted the Hungarian idea for many reasons. One was this international context, but also because this way they can neutralize territorial autonomy claims, because even Hungarian minority, but other minorities had strong territorial autonomy claims. If you provide a non-territorial model, then you can ease the situation and neutralize territorial autonomy claims. About the concept, I said it's a Hungarian concept. It could be traced in these documents. It means one central assembly of a national minority, democratically elected, with strong capacity for agency. So assembly, elected by the members of the minority, and various powers and competencies in the area which is connected with the identity. So culture, education, mother tongue education, media, and also official language use. And the idea was that the existing institutional framework, schools, theaters, museums, cultural centers, to come in a way under the umbrella of the National Council. So the public institutions financed by the state to come in a way under the common umbrella of the democratic elected body. So it was about power sharing, an anti-majoritarian arrangement in order to prevent the, let's say, the oppression of minority by the democratic majority. So the legal framework, I will not elaborate all stages, just very briefly. So from 2002, it was a rudimentary framework accepted by the federal parliament, but it was only 2 articles in this law. So it was very framework regulation, but there was one of these articles was about the provisional establishment, how to establish provisionally till we have a comprehensive law regulating this issue, how to establish these national councils. The idea was not only to declare that you have self-government, you have national councils, but to oblige the legislator to regulate it further, and also to make it possible tomorrow to establish national councils. So not to have only legal provision, but practical possibilities. This provisional article made it possible to establish national councils, but with the way of electing members by electors. So not direct under the voting register, but through the model of electors. In this period, till 2009, this is the first stage, we have election of 13 national councils. So in this period, altogether 13 minorities established their national councils. The Hungarian was not by chance the first one in 2002, but many was established in 2003. But what was the problem? The parliament rejected to enact a new law on national councils. So we have 7 years elapsed from the federal law till in Serbia, we have a 2009 law on national councils. It's the first stage. So the government was reluctant. Okay, we declare that you will have national councils, but the precise competencies, powers, establishment, we are not too much interested. But finally, there was also pressure about with advisory committee for the Framework Convention. They warned that you have obligations, and the first mandate of these national councils were terminated. So they had no legitimate assemblies from 2006 or 7. So the second stage is the law, which comprehensively regulated every issue around national councils. It has 138 articles, so it's a big law about elections, about competencies, about status issues, electoral rules, etc. This comprehensive law was amended 3 times till now. The first was in year 2014, mainly about electoral rules. The next one was the decision of the Constitutional Court, which invalidated more than 10 articles of the law, And we had a third one in year 2018. Just to go further, we had elections. The number of elected national councils is bigger and bigger in every mandate. We had 13, today we have 22 national councils, and the number of registered voters is also increasing with years. Today we have almost 500,000 registered voters in this special register. The Constitutional Court decision, very briefly, is really extraordinary decision in many aspects. It's extraordinary because in 60 years old history of Constitutional Court in Yugoslavia and Serbia, it was the first decision which comprehensively dealt with minority rights. No decision before that had dealt with minority rights and their implementation. The second thing was that it gave it had the ambition to give strong doctrinary foundation for the decision. It tried to elaborate the concept of minority rights, the concept of self-government. And the third one is that it's a rare situation in which the Constitutional Court simply invalidate a large number of provisions of a law. So the Constitutional Court of Serbia very rarely is doing that. And usually they say that how one right is implemented is up to the legislator. We cannot influence that, but it is exception. It is exception, and they invalidated 10 articles. But what is a very interesting point in this, that they cannot find real constitutional basis for invalidating these articles. They invalidated most of them because they were not in harmony with sectoral laws, for example, in education or media. So it was not contrary to the constitution, but it was not in harmony with other law. And according to the Serbian constitution, laws are equal. So there is no hierarchy between them. But despite of this fact, the Constitutional Court said that this contradiction is a basis for invalidating these provisions. And in sometimes, even there was no such place, they say it went out from the affirmative measures for the protection of minorities, out of the framework. But they never explained what is this framework, where are the limits for that. It said it went out. And what is also interesting that the court protected because there was many initiatives. Almost half of the provisions were attacked by initiators. All provisions which were about direct elections, separate voting register, establishment, etc., were spared by the court. They said it is absolutely okay. And mainly the powers and the competencies were simply invalidated. So it's a very interesting. So the major unresolved issues. So after this Constitutional Court decision, finally in 2018, the Parliament in a way harmonized with this decision the provisions of the law on national councils, but not in a way that they changed the sectorial laws. No, they put provisions in this law which are absolutely the same than in sectorial law. So they diminished the standards around the powers of national councils. I identified 3 unresolved issues after 19 years, which are simply on the back of this system of national minority councils. The first is, till now, it's not legally resolved whether these are private institutions, NGOs, or part of the state organizations, public bodies. And if you analyze the provisions in the Serbian legal system, you can find arguments in support which said these are public institutions. Democratic elections organized by the state electoral committee, which organizes all elections, the special register, public powers, all show that they are public institutions. But there are other laws which simply said that they are not. For example, incompatibility of functions. We have laws about preventing incompatible functions. Functions in national councils are not part of that story. The second issue was party politics in national minority councils. It from the beginning is something which is on the neck of this issue, whether to allow political parties to take part and which political parties. From the beginning, the situation is that minority parties are allowed. Let's say, state parties are not allowed to participate. But in actual practice, they are participating through NGOs. And in the majority of these national councils, they have the ruling stake. So they made it possible to manage these councils, except those minorities, in the case of those minorities which are very strongly politically organized. These are the Hungarian, the Bosniak, and the Albanian. In these cases, the state parties were not able to take over national councils. But what happens that the winner in these national councils, the political party gaining majority in these national councils, is simply working like in Westminster model of democracy. So winners takes it all. And simply these cultural issues, which are really not party political issues, becoming issues of outbidding, outvoting, overvoting. And what happens simply that these parties are using this institution to spread their influence in a way to gain some advantages through these institutions under the national councils. And the third unresolved issue is that it's the same framework for very different minorities. So it's a Hungarian concept in which the management of institutions putting under the umbrella of the national council is the basis, but we have minorities without any institutions. We have new minorities in Serbia, 22 minorities. Majority of them had no official language use, had no schools, had no cultural institutions. So the framework for them is not really fitting. So these are very different minorities and the framework is same. Conclusion. Today in Serbia, the minority national councils and non-territorial autonomy is deeply entrenched. It is in Constitution. Article 75 of the Constitution guarantees their existence. And in this respect is different than in other comparative places except Slovenia when they are also entrenched. No one really in Serbia today questions national minority councils. There is no political party which said we will ease them out. But no one really is ready to make them a real power-sharing institution. So they are, after the decision of the Constitutional Court, much more consultative body, but then a self-governing body, which is written in the Constitution. So today we are in such a situation that it seems that it will be part of the institutional system of Serbia permanently, but without real decisive role. In 2013, yes, I finished. 2013, the Framework Convention Advisory Committee concluded in report on Serbia that national minority councils are today the major and decisive institutions in the implementation of minority rights. After 8 years, we will disagree with this statement.